Good morning, and thank you to everyone who's joining us. My name is Jessica Tillotman, and I am the Assistant Dean for Government Procurement Law at the George Washington University Law School. We are delighted to welcome you today to this excellent program co-hosted by the World Bank, the ABA International Section of Anti-Corruption Law, and of course, the GW Law Government Procurement Law Program. With that, I'm going to turn it on over to the host or co-host of today's program, Collin Swan. Thank you, Collin.
Thank you, Jessica. And again, thank you to the GW Law Government Procurement Program and the ABA International Anti-Corruption Committee for co-hosting this webinar. I'd like to welcome all of you for tuning into what I hope will be an insightful dialogue on the recently published Global Suspension and Debarment Directory. As Jessica mentioned, my name is Collin Swan. I am a senior counsel in the World Bank's Office of Suspension and Debarment. I was also the team leader for the directory project. I'm joined here with my co-moderator, Nicholas Dukelis, who's a legal consultant at the Office of Suspension and Debarment and played a significant role in helping to put this directory together. We have an exciting panel lined up to discuss the directory, its findings, and several broader issues on suspension and debarment. And I'll let them introduce themselves in a moment. But before I do, Nicholas and I just wanted to take a few minutes to present the directory, which to our knowledge is the first consultative resource on exclusion systems. So a little bit of history to start. The idea for this project began in 2015 when several of our predecessors in the Office of Suspension and Debarment began to systematically study how countries from around the world use exclusion to combat fraud and corruption and protect against performance risk. This preliminary research discovered a lack of commonality across jurisdictions and a significant gap in the research on exclusion mechanisms specifically. This led to the development of a survey questionnaire and a couple of research partnerships with the International Bar Association's Anti-Corruption Committee, the Sanctions Officer for the Inter-American Development Bank Group, and the Montreal Inspector General's Office. Simply put, the goal of this project was to gather knowledge and comparable data on exclusion systems from as many jurisdictions as possible. And I'm going to turn it over to Nicholas to discuss the survey process and the methodology that we used.
Thank you, Collin, and thank you, Jessica, and thanks to everyone for joining us today. Our team initially developed the survey questionnaire to seek the insights of multiple experts for each of the 23 jurisdictions and institutions surveyed. The experts who graciously shared their knowledge and experience were asked to respond to almost 70 questions covering 6 areas relating to their exclusion system structure and operation. These areas included questions relating to whether there is a government-wide legal and institutional framework for exclusion, how does this framework function and how it is enforced, what are the substantive grounds for exclusion, what is the scope and effect of an exclusion decision, are there transparency mechanisms such as a public debarment list, and are there any limited scope exclusion options? Our team then worked with the experts to convert their responses into the summary for each of the covered jurisdiction. All the summaries together form the Global Suspension and Debarment Directory, which is accessible online. Through this process, we identified a few criteria that we use to group exclusion systems, such as who is the decision maker, whether the decisions are made as part of the procurement process or by an independent decision maker, whether the decisions have government-wide effect or only or effect on only a specific procurement process, and whether there is a public list of excluded suppliers. These criteria ultimately evolved into the filters of an interactive table that accompanies the directory and can be accessed online. Looking at the categorization and applying the filters in the table, one easily concludes that there is not a one-size-fits-all approach when it comes to exclusion. Many nuances exist between systems, but also within exclusion systems themselves that make it difficult to neatly categorize certain jurisdictions. I will now turn it back to Collin to describe certain broad conclusions based on the findings of the survey.
Thank you, Nicholas. Yes, as Nicholas mentioned, there are a lot of nuances that were discovered that took a lot of time and attention to categorize or try to describe exactly how each system was applied. Nevertheless, there are some broad findings, high-level takeaways that we drew from our research. The first is perhaps not a surprise, but it might be, is that exclusion systems are quite common. They are prevalent. Only one of the 23 jurisdictions that we reviewed in the directory did not have any type of government-wide exclusion framework at the national level. Also, the second big finding is that all of those jurisdictions that did have an exclusion system provide some opportunity for the accused supplier to respond to or challenge the basis for the exclusion. I do, however, have to caveat this finding with a pretty big caveat in that the timing of this opportunity varies widely across jurisdictions. Not every jurisdiction, in fact, quite a number of jurisdictions do not provide this opportunity before the exclusion takes effect. And in even certain other jurisdictions, the opportunity to challenge is limited to an appeal to, for example, a court of law or to some other government agency or body. Beyond that, we were able to roughly identify or focus on 3 high-level features in an attempt to kind of categorize each of the jurisdictions. Again, as Nicholas mentioned, there is a lot of nuance. These are not perfect categorizations by any stretch of the imagination, but I think they do help to illuminate some of the purposes or some of the functions of a system. So the 3 high-level features that we looked at were, first, how is the decision made? How is the exclusion decision made? The second is who makes the decision? And the third is what's the effect of the exclusion? So looking to the first, how is the decision made? Roughly, you can distinguish between administrative and judicial systems. So in about 4 jurisdictions, the exclusion is a penalty that can be imposed by a court of law as part of a conviction or a sentence. In the vast majority of the rest of the jurisdictions, exclusion is an administrative remedy that's imposed by a government agency, either a procurement official or some other independent decision maker. Once again, I have a caveat for the administrative remedies or the administrative systems, because in many of those jurisdictions, they will use a conviction or a court judgment as the basis for the exclusion. But we still treated these jurisdictions as administrative systems because while the conviction or the court judgment was imposed by a court, the actual exclusion is imposed by a government agency or official. Turning to the second high-level feature, who makes the decision? Again, 2 rough, very high-level categories. The first are systems in which the procurement officials are making the exclusion decisions as part of any given procurement process. So in these types of systems, the exclusion decision is essentially part of the qualification review of each of the bidders in a given procurement. And then the other bucket of jurisdictions, and these are about roughly equal, about 50-50. The exclusion decision is made by an independent decision maker who is outside the procurement process and is specifically charged with evaluating and making exclusion decisions. The United States is one example. Each agency at the federal level has a designated suspending and debarring officer charged with making these decisions. And then the third, the effective exclusion. Again, 2 rough buckets. In the first, an exclusion decision has government-wide effect. That means an exclusion that is imposed on a supplier by one agency prohibits that supplier from doing business with any other agency at the national level. This is usually accompanied by a public listing of all of those suppliers that are excluded. In fact, about 12 of the jurisdictions reviewed in the directory have a public list. An additional 2 jurisdictions have non-public lists that are available to government officials and third parties on a need-to-know basis, but aren't publicly available. The other category is contract by contract exclusion, which means that the exclusion decision disqualifies the bidder from the particular procurement process they're bidding for and does not extend further to other agencies or even other procurement processes. That doesn't mean that the grounds for exclusion disappears. It continues to exist, but the impact of the specific exclusion decision made by that procurement official or by that officer is limited to that procurement process. One final point, again, turning to the nuances that we discovered, is that several jurisdictions provide more than one avenue for a supplier to be excluded. In fact, we rarely, in our review of the laws and the frameworks, found an exclusion-specific statute or regulation that applied. More often than not, the exclusion provisions were interspersed throughout various statutes and regulations. And depending on the applicable statute or regulation, depending on the specific grounds you're looking at, that can then impact how that exclusion is applied. So those are some of our specific findings, our own review of the directory, but I'm very excited to bring in our panel and get their thoughts on a lot of these issues and topics. Before I have them introduce themselves and we launch in, I wanted to note for all of you in the audience that we are taking questions. We will do our best to answer and incorporate as many questions as we can. To answer questions, please go to the chat function at the bottom and type in your questions to all of us. Nicholas and I will do our best to incorporate that question into the discussion at the appropriate time. But we do very, very much welcome questions from all of you. Okay, so turning to our esteemed panelists. I'm going to have each of you introduce yourselves really, really quickly. Jessica, you've already introduced yourself. Carlos, would you like to go ahead?
Hi, thank you, Collin, and everyone for participating here. I'm Carlos Aires from Maedaides and Sarubi Law Firm in São Paulo, Brazil, and I'm professor of FGV Law in São Paulo as well.
Thank you, Carlos. Welcome. Juan?
Thank you very much. My name is Juan Ronderos. I am acting here both as the sanctions officer for the Inter-American Development Bank and co-chair to the Debarment and Exclusion Subcommittee of the International Bar Association Committee on Anti-Corruption.
And last but not least, Mirella.
Hi, my name is Mirella Lechna. I'm an attorney at law, a Polish practitioner. I practice in a Polish jurisdiction in the law firm Wartyński & Partners. I am also a PhD researcher at the Nottingham University in the field of public procurement.
Welcome, and all of our esteemed panelists had some involvement in the directory. And in fact, I have to point out Carlos and Mirella were both significant contributors to making this possible. So just a thank you to both of you and to all of you. I'm now going to turn it over to Nicholas to get us started with the first question to the panelists.
Thank you, Collin. I would like to ask all the panelists to briefly describe their experience with exclusion in their jurisdictions and very briefly focus on the key elements of their system and how that system has evolved over time. And subsequently, I would like to also ask what were their major takeaways from the directory and whether there were any surprises based on the findings, and how the directory itself can help promote our general knowledge around exclusion systems. I will like to start with Jessica first.
Thank you. So if we want to talk briefly to answer the first part of your question, to give just a very brief snapshot of what happens in the United States when it comes to exclusion. We have a fairly mature system in the United States, to no surprise. It's grounded in this concept of responsibility, that the United States government only wants to do business with what they refer to as responsible contractors, those that have the ethics and compliance, the ability to perform. They're not engaging in fraud and corruption, among many other things. But again, it's this concept of responsibility. And the purpose of our system is to protect the government's interest, to protect taxpayer dollars. So that kind of concept of responsibility is really embedded throughout how our system is structured. And I know we're going to get into more of that in a little bit. Really, it's the United States operating with its business hat on when we're talking about exclusion. We're not talking about punishment or something that would typically be taken up by our Department of Justice. It's again acting with a business purpose in mind when determining this concept of responsibility. We have a fairly, it's federal in nature, but the system itself is fairly decentralized among the agencies. Generally, each agency has their own suspension and debarment official. Some agencies have a few more, depending on the agency. But even though the decisions are made by a single suspension and debarment official, they have the ability to then bind the entire federal government. That means the exclusion decision is government-wide. Our system, it can be both formal and informal. There's some agencies that have a much more formal process. There are many other agencies where, you know, somebody's lawyer could just call up a suspension and debarment official and have a fairly informal meeting and discussion about a contractor's present responsibility. And really, when a suspension and debarment official is taking into account whether an individual or an entity should be excluded, it has a two-step inquiry. First, the SDO looks to whether or not there's cause, and there's a fairly lengthy list of causes for potential exclusion in the United States, which I won't get into because that will take me beyond my time limit. And then the suspension and debarment official will ask, even if there is cause, even if, for example, a contractor engaged in fraud, is it still necessary to protect the government's interests? And at that point, the suspension and debarment official will look at things like mitigation and compliance measures and other sorts of things to say that even if there was bases, is it still necessary to protect the government's interests? And that two-step process is really critical, essential to how we do exclusion in the United States. There's a very heavy emphasis on mitigation measures taken by individuals and entities. My big takeaway, the second part of your question, from this debarment survey, I was actually pleasantly surprised to see the level of transparency in some countries' debarment systems. I know Carlos could probably speak to Brazil, which I was impressed with as well. One in particular too, even in South Africa. In the United States, we often tout our transparency in our procurement system, and we have many different vehicles for promoting transparency. And indeed, the names of companies and individuals are provided in our system for award management, or SAM.gov, for people to see. However, we don't really provide much insight into what happened with the company. There's this very kind of broad, you know, bases for why the company's done it. It just really kind of quotes some template language, but we don't get into the reasons for exclusion. That stuff just really isn't released publicly. Whereas compared to the World Bank and other jurisdictions, I was really excited to see greater transparency. And I think for many of us that are kind of in this ethics, compliance, anti-corruption area of the law, I would love to see more transparency in many of the jurisdictions that answered this survey, including the United States.
Thank you, Jessica. Carlos, the same question.
Well, the system in Brazil is more towards government-wide exclusions. We have some specifics, but I would say that we have multiple decision-maker system, and that's in many countries in Latin America, in which you can have like judicial decision applying sanctions that can be at the entity level. And in many jurisdictions, as in Brazil, the exclusions are largely administrative. And in principle, one might think that is quicker and more flexible, right? But not necessarily more effective. What happens is that virtually any entity that does public procurement can debar a company or an individual, but that entity might not have the expertise or even the legal education for those carrying the sanction. And what happens is that creates a lot of nullity because of lack of due process. And what I see very often is that many cases, they are dismissed even when the facts could justify a sanction, because those who were carrying the process were not following due process. And when you go to the small corners of the countries, also you might face challenges like lack of independence, conflicts of interest. One thing that I would highlight in Brazil, which I think is very interesting, is that ongoing contracts are not automatically canceled, and that is determined on a case-by-case basis, because the termination in certain cases could cause more harm than the continuation itself. And another aspect that I would highlight is that certain debarments, they might remain until the supplier fulfill certain requirements, which can be reimburse the damages caused. So as long as the company cannot be doing business until they reimburse the damage. And one thing that is new in Brazil at the federal level, and I know other countries in the region are looking into this, in order to be able to resume doing business with the government, the company needs to demonstrate that it has implemented a compliance program in place. In terms of how things evolved over time, I would point out the possibility of settlements to avoid debarment. That is relatively a new concept. Until 2014, companies would deny until the very end, but now if they self-report, give new facts and admit participation in wrongdoing, they can have fines reduced and the exclusion taken out as well. And other countries in the region are looking into this. So in terms of recent develops, I would highlight that and this notion of rehabilitation. And with respect to the last question, very quickly here, I think Collin summarized well the takeaways. What caught my attention was that a few countries, they have zero or very limited sanctions. So that was something that caught my attention. And also to Jessica's point, many countries, they have a public list of debarred entities, which I think, and the directory mentions those lists with links, so forth and so on, which I also think is very helpful for companies conducting their due diligence. So these would be my main observations.
Thank you, Carlos. Juan?
Thank you very much. So I'm going to try to make a very quick summary of our systems at the multilateral development banks, because the IDB, like the World Bank, is a multilateral development bank. And with its 5 multilateral development banks that we have joined together in a cross-debarment agreement, meaning that we have linked our debarment systems and exclusion systems in a way that if one of our entities sanctions a company or an individual for more than 1 year of debarment, then the other institutions are going to follow suit, and they're going to publish the names of those persons or entities in their websites as well. So we are international institutions governed by international public law. We have a system of debarment that is governed by administrative international law. It is an administrative system. It's a quasi-judicial system in that we have an office that conducts investigations, that is independent, and we have a 2-tier system in our multilateral development banks in charge of making these decisions. Those decisions can end up in a number of different sanctions, but the most common one is debarment. That is the one that is common all across the different institutions. And those institutions are the World Bank, the Inter-American Development Bank, the Asian Development Bank, the African Development Bank, and the European Bank of Reconstruction and Development. We also have the European Investment Bank that is not part of the cross-debarment agreement, but has a system for debarment as well. So we have been doing this for the past, since we have the cross-debarment agreement since 2010, so it's going to be 11 years. But our systems have existed for almost 20 years, and we modeled the systems out of the US system that Jessica was mentioning before, except that we sanction for 4 prohibited practices, which are the ones that have been harmonized: corrupt practice, fraudulent practice, collusive practice, and coercion. And we conduct our investigations independently and issue these sanctions. The interesting part for Latin America and the Caribbean, for instance, is that when we, first of all, our bank lends about $12 billion a year in Latin America, and most of it goes in procurement in all the countries that we serve. So if a company gets the bar in one country, it automatically will be the bar in all the other countries and all the procurement that is related to our funding. And if it's for more than 1 year, it would be cross the bar in all the other countries that those other banks serve. In looking to answer the second question that Nicolaus placed was, what is the takeaway? And for me, the takeaway is the level of sophistication and development that these systems have had, especially in the Americas. But the second one is that this is the first time that we make an effort to try to bring all of these different systems in light of everyone. So each country has its own debarment system, it has its own exclusion system. But now, it is until now that we're starting to see that many countries have these systems. And in today's world that it's interconnected and you have companies bidding across borders, you're starting to see that the effects of an investigation and an exclusion or a debarment in one country may have effects in other jurisdictions. And that is very key. And I think that this is the first effort of having all these different systems in one place. So this compilation that we have, I think it is fundamental in today's world from the procurement point of view.
Thank you, Juan. And Mirella?
Thank you, Nicholas. Polish exclusion system is a part of the European public procurement law. And therefore, there is a lot of solutions that we adopt that are decided at the EU level. Basing on that, our system, the key elements of our system is the division between the exclusion grounds into mandatory exclusion grounds, which must be applied, and they are decided at the EU level. And they are decided in a specific context of the offences that are of concerns of the EU law. Other grounds, the group of other grounds is the discretionary grounds for exclusion, and they cover different cases of bidder, which is, for instance, the bankruptcy, the winding up order, or when the bidder is guilty of grave professional misconduct, or have failed to pay taxes or social security contributions, but without any verdict in this respect. Also is guilty of the breach of environmental, social, or labor law, and also misrepresentation in supplying information to the contracting authority. These discretional grants applied, or decision to apply them, is made on a domestic level because this is the best place to decide whether or not they address the different local considerations or objectives actually the public procurement in a given jurisdiction is to address. What is important, the character of the exclusion grant may be changed into mandatory from this discretionary by the member state. However, contracting authorities may not be limited in applying discretionary grants by the member state. It means this is the right, and if they feel this is useful for any reason to apply them, they may not be restricted. This is actually the key element of the system, and I think we will be discussing this system a little bit more later. But there was also the question about the evolution, and this is quite important because actually the evolution under EU law related to the purpose of the system itself. The principle was that the exclusion system may not, or the exclusion may not take place for the reasons which are not related to the contract being awarded, which means it was strongly connected with the reliability or ability to perform the contract, to deliver the contract. However, there are certain exclusion grants which do not have this direct link with reliability to properly deliver. So there were certain interpretation and court rulings, and it was the view taken that actually the exclusion grant situation are perceived as creating the presumption that certain bidder is not reliable or honest enough, and thus cannot be trusted to perform effectively and legally. That was the concept. Also, the other one was that by applying exclusion grants, there is an ensuring of the level playing field, because in this way, the rule of fair competition is addressed. Otherwise, we could accept the unfair competitive advantage that might arise if there is a non-compliance with the legal rules by one of the bidders. But the other views were also, as Jessica presented, it was not allowing associating the government with unlawful behavior, or exclusion grants were perceived as additional enforcement tool to secure compliance with the law as a sanction. In 2014, where the new public procurement directives entered into force, the more emphasis was placed on reliability. And first element to perceive the system in this way is explicit self-cleaning defense. It is the defense against exclusion when the bidder can prove that the reliability is no longer affected. And this also is the emphasis on the orientation of the exclusion grants and the firm's current situation, which means that it is not available anymore to exclude firms for the past records of violence of the law. There is only one case when the situation may not be self-claimed by a bidder. It is when the ban to take part in public procurement procedures is itself set in a court ruling. So this one case allows for the punitive character of the exclusion system in Poland and the European Union. As regards the directory, I must say I was a little bit surprised by the outcome, by the conclusion, because studies explain that there's a phenomena of convergence in the public procurement, which means that public procurement systems tend to, over time, to resemble each other in terms of desiderata, requirements, and procedures. But the directory proves something different. There's a lot of differences, and also including that fundamental one: what is the purpose of the exclusion system? As we could see with the self-cleaning defense, there may be reliability underlying in this exclusion system, the encouragement for abiding with the law, which is perceived better than by exclusion. However, there are some tools, like for instance, I remember in Canada, like the ban or debarment is for 10 years. It is obviously for the punitive reasons. So that was actually quite useful takeaway from that directory.
Thank you, Mirella. And this is actually a perfect segue into our next question, which is directed at Jessica, but then, I would love for everybody else on the panel to weigh in, which is, commenting on the purpose of exclusion and debarment. This purpose question is something that I think comes up almost every time that I have a discussion about exclusion, and it is a really, really important and fundamental one. And Jessica, you had brought it up when we were having our prep call a couple of weeks ago. So, I was just wondering, comment on, why is it important to understand the purpose of an exclusion? How does the purpose of a system affect its ability to function?
Sure. So to me, it's the fundamental question, because it explains a lot of the decisions that often come from exclusion regimes. Not in every instance, because there are certainly some exclusion regimes, as you can probably tell from looking at lists online that are public. Some are more robust than others, but it definitely explains a lot of decisions. I will use the United States as an example. One of the most fundamentally misunderstood aspects of our system is that it's not a tool of punishment, it's a tool of protection. And that goes a long way in explaining why certain debarment decisions are made. There's a lot of often there's a lot of outcry when a large company isn't excluded from a system after a very high profile corruption scandal or fraud scandal. There's a lot of misunderstanding. We often see it from sometimes our even legislative branch, or even policymakers or the media. And the fact that within at least the United States, debarment is not used as a tool of punishment protection explains a lot of the rationales behind those decisions. When you're looking at the system as a tool of protection, you're looking not just at the cause of debarment. Did a company or an individual engage in some sort of exclusionary types of behavior, whether it's fraud, corruption, grossly poor performance, tax evasion? We could go down the list of fairly common causes for exclusion, and kind of across the board. But then when you look to what I highlighted in my initial statement, the second part of the two-factor analysis, even if there's cause, is it still necessary to exclude that entity in order to protect the government? That really gets to the purpose, because if a company or individual has taken the steps necessary to demonstrate that they no longer pose a threat, they've fired responsible employees, they've overhauled their ethics and compliance program, they've remediated a lot of the issues that were at the heart of what caused this misconduct, then it no longer poses that threat to the system. So if a system looks at it purely almost as a business decision, and whether that entity still poses that threat, that goes a long way in explaining why sometimes we see instances where fairly large companies who have already pre-existing fairly robust compliance programs are better able to avoid exclusion because they can take the necessary steps to remediate, to mitigate the harm that's been caused by the misconduct, and demonstrate to the debarring official why they are still responsible, why they should still remain eligible for contracts, and why, conversely, when we're dealing often with individuals and smaller entities, they're not as equipped to fully remediate or fully alleviate the concerns of a suspension and debarment official, because it's much more difficult to fire responsible employees when you have 15 people in a company and most of them are responsible for the misconduct. Same with individuals, it's much more difficult. So that's why we often see disparity in a lot of these decisions. And again, understanding the purpose goes a long way in explaining why we see these differences.
Would any of our other panelists like to weigh in on this?
If I may, to have a question to Jessica, you mean protection of the government and pose a threat. Pose a threat meaning improper delivery of the contract. What is the protection really about?
It's a great question, and we use that kind of broadly. So sometimes we say it's protection of taxpayer dollars to make sure that when we are funding procurements or even grants or other types of activities, that we're doing it with companies that we know that aren't engaged in fraud or corruption, or because, at least in the United States, the bases for exclusion are so broad, even from grossly poor performance. So the protection is to make sure that taxpayer dollars are being spent the way that they're supposed to be. Again, also to protect the deliverables, the service or the goods being provided to the government. So I'd say it's protection in almost the broadest sense of ensuring we're getting what we paid for. And again, what's being provided is actually what the government bargained for.
Okay. So that is, like, I would say, totally different than in Poland and the EU system, because it is enough in Poland to stop being involved in the wrongful conduct and prove that the reliability is regained, and this is enough to defend from the exclusion. Apart from that example, that is the court wording with a ban to take part in a public contract, but this is a different situation, specific one.
Yeah, and I think that's an interesting point to raise. I think ultimately a suspension and debarment official within the United States would not want that type of conduct to occur, because it poses a threat to misuse of money, corruption, all other kinds of harms we'd be concerned of when we want to make sure we're dealing with ethical suppliers. But a lot of those behaviors, when you're talking about stopping kind of misconduct type behavior, will also be dealt with from a prosecution standpoint and are often being dealt with from some sort of enforcement mechanism. There's a fairly layered approach. Whereas, again, if we're dealing with the business hat in the suspension and debarment system, we're concerned with making sure that the government is getting what it paid for with reliable, responsible companies.
So similar to this, I maybe would like to bring Carlos and Juan in to this particular discussion. We have a question from the audience. We have a couple of questions in the audience. One is specifically about collateral consequences and sort of the extent to which that is taken into account. So I was wondering if that could be discussed. But more broadly, we talked about, I talked about in my my sort of overview of the directory, and Jessica had mentioned it a couple of times. There is often in a lot of these jurisdictions, exclusion is administrative, and so there's an administrative process to it. It's not judicial. In a lot of countries, there is the possibility for both remedies, and so I was wondering to what extent, by making exclusion or by keeping exclusion an administrative focus away from the traditional kind of legal proceedings in the criminal or in the civil liability context, does that make the remedy more versatile and flexible? Does that impact the purpose for which it's provided? I mean, in the United States, I often think of the reason that the United States and other countries can use exclusion strictly as a protective tool is because there is the judicial criminal process that is available to take the punitive act against anything that is truly criminal. So, Carlos or Juan, I guess from the MDB context, there's a little bit of a difference there. But Carlos, from Brazil or Latin America's perspective, I guess, do you see any similar trends?
That was a question that was raised in the past, Collin, of the collateral consequence. And what happened is that Brazil, to address that, in the recent past, passed a new law that outlines the factors to be taken into consideration in applying sanctions. So the authorities have to analyze the nature of the violation, the peculiarities of the case, the existence of aggravating or mitigating circumstances. And also one thing that was included is the existence of a compliance program in place. I think that's a good development, because we have seen cases in which companies were debarred in the region because they delayed a few days, the delivery of certain products, and they were, debarred for many years. I think the challenge in Latin America and in other countries is that we have the family-owned groups, right? In which the government really wanted to, hit that person or the company, which it's different when you have like a corporation with different shareholders. Then, you might end up with the collateral consequences hitting people that have nothing to do with the violation, right? But then in Latin America, we have these family-owned groups, which makes this more complex. But we still have a long way to go. And I'll give you an example. We have a case of a large European company that identified wrongdoing and self-reported to the authorities in Brazil, facts that were not under the radar of the authorities. And that if the company stayed quiet, probably the government would never find out about it. And the company did so, which was a good thing. And as a result, the authorities filed a lawsuit against the company seeking fine, restitution, and that's okay, but they were also seeking like dismissal of the legal entity, debarment, which makes no sense, right? And the company was so involved in many things that would stop the state. And it was a large multinational that does, regular business. So I think that's a challenge, but I think that is evolving. I think these new laws that are passed are trying to address this. And I see that many countries are looking at what's happening in Brazil in that regard in Latin America. So hopefully that will be replicated to the region in the near future.
Yeah, what Carlos has been mentioning about the developments in Brazil, they're huge in Latin America, and it has created a ripple effect in many jurisdictions in the region. From the point of view of the MDBs, the origin of our system comes from the Articles of Agreement of all our institutions. All our institutions pretty much have the same clause in our Articles of Agreement that says that we have a fiduciary duty to ensure that the funds that are entrusted to us go for the intended purpose. That means development. So we have a policy of zero tolerance to corruption. But at the same time, we don't forget we're a development agency, and that means, and we're all trying to effect development in the region. So the tools that we have created them in a way that we can answer to the challenge of trying to exclude those companies or individuals that commit one of these prohibited practices, especially corruption, fraud, and collusion, but also have a measured response in those situations in which we see we can do something better in the market or in the country or in the region in which they're acting. And that is through, in addition to debarment, include different forms of sanction, like including compliance programs. So more and more compliance is becoming part of the kind of sanctions that we're imposing, and we are requesting monitors or monitorships on certain companies to ensure that they actually clean the companies and try to come up to an international standard, or try to bring up standards in certain sectors, so things go smoothly and we can actually affect positively development in those regions. So I guess to answer one of the questions that was posed in the thread, I think by Kathleen, and hi, by the way, is that I think that the answer that we're having from the MDBs to this kind of actions is not like it used to be before, just by debarment, the plain debarment, but also trying to mix with other types of sanctions that we have in our toolbox to try to respond in those cases in which the exclusion of a company completely out of a market is not the answer, because you're not going to have a positive, a positive effect, which is what we intend. So it's not just excluding companies by excluding companies, but there has to be a purpose behind it. And for that, we have the issue of development, which is our main thrust as the standard that we use.
And based on Juan's remarks towards the end, I would like to broaden the question a little bit and ask in the EU, Mirella, and in Brazil, Carlos, how is compliance programs? How are compliance programs viewed either proactively or during an exclusion process? And then in that context, also try to answer some of the questions from the audience, asking whether there is evidence of changing corporate behavior and creating better value for money for public authorities because of compliance programs. And then also, are there any particular trends in using integrity compliance monitors in each of your jurisdictions? So I would like to start with Mirella. Mirella, you're on mute.
Sorry, I start with explaining that the exclusion decision in Poland and the EU is made on a contract by contract basis by the contracting authority, and it is made on the basis of the facts. Obviously, there are some supporting documents which will help the contracting authority to prove, to evidence that these facts really happened. By saying this, I want to explain that compliance programs may not necessarily be taken under consideration when evaluating the exclusion grant situation of the bidder. They can be taken under consideration when there is a self-cleaning defense instituted by the bidder, but they are not an element that is decisive in that process. Actually, self-defense is quite difficult and very rarely successful in Poland. It is the problem which results from the fact that it is made by the contracting authority as well, and not by the centralized body or someone that could have better resources or could secure higher quality of the decision making in this respect. Shortly speaking, evaluating whether measures taken were sufficient or not is really too hard for the contracting authorities to establish. And this is why we do not pay that much attention to the compliance program, because we have a list of several elements to be fulfilled when we want to show that measures were sufficient and were taken by the contracting authority, by the bidder, to show the contracting authority regaining the compliance. However, the reliance, but compliance program is just one of the elements with not that key importance in the whole process. Other elements are also important. There was a question from the audience whether there's damage must be redressed, and yes, this is one element, that the damage must be redressed. For instance, links with persons involved in the misconduct are no longer in the company, so the company is cleaned. And integrity compliance program is one of the elements of that evidence process.
Here in Brazil, Nicolaus, what happened is that a few years ago, many states started to require compliance as part of the public procurement. So companies, they either had to have one when they participate in the tender, or they would have to implement one in 6 months for contracts above a certain threshold. At the state level, this was, not very high, like $100,000. And in the earlier this year, a federal law was passed which requires companies to have compliance program for any public procurement above 200 million reais, around 40 million US dollars. One might think that this is a good thing, right? The issue is that, you might end up having, 6 months, a short time to implement a compliance program, especially in a large company. And at the state level, the way this has been dealt is that the manager of the contract is the one responsible for assessing the compliance program. And he or she, the poor person, is already too busy managing the contract and might not have the expertise, right? So, and I have seen companies, large ones, coming and said, hey, Carlos, what is the minimum that we need to do to say that we have a compliance program in place? So that's not a good thing. Hopefully, and the good thing about this new federal law is that CGU, the Office of the Comptroller General, who have been following compliance program, they have a highly qualified and expertise in this field and a strong technical team. They are working to regulate how this would play. So hopefully something good will come out of it, at least at the federal level. And also, under this new federal law, compliance programs are taken into consideration if there is a tie. So 2 companies with the same bids, compliance program will be something to differentiate them. And also the compliance programs, they will be considered in the application of sanctions to determine which sanctions will be applied. So hopefully that can be used for serious companies to avoid debarment, and also compliance is required for companies to do business, resume doing business after being debarred by the government.
Yeah, one thing that I wanted to mention is that 5 years ago in Latin America, nobody was talking about compliance. Now you have countries that are requiring compliance. It's mandatory in certain cases, and you have very developed countries developed compliance systems in Latin American countries like Argentina, Chile, Colombia, Costa Rica, Mexico, Peru. And the question is, how do you create those systems? One thing that we're starting to see from the IDB perspective is that because the majority of the companies that we sanction are small and medium enterprises, is how do you apply a compliance program to a small company? And Hui Chen, who's an expert on this topic, has written about it, and it's fairly complex because you cannot ask a mom and pop shop to create a compliance program as complex as the one that you would have for Siemens. And so the question is, like, what is an effective compliance program, and how can you assess that at different levels? And then once you have that, how can you have different systems within different countries? So given that 5 years ago, as I said at the beginning, we had no compliance programs, and now we're having compliance programs being required everywhere, and having all these different levels of advancement in different places, is still to be seen how this is going to play out in the long run. So we take into account compliance programs when we look into sanctioning entities. We have compliance programs as a way to mitigate sanctions, but we're still developing how we assess them, and how we are going to be looking at this within 5 years is going to be very interesting.
I just wanted to jump on the Juan bandwagon there. It's certainly a completely different landscape than we were dealing with 5 years ago, 10 years ago. as you're saying, whether it's SIP and France who affirmatively requires it, the FAR in the United States does require contractors of a certain size and type to have a compliance program as well. And to rival Carlos's anecdote, years right after that FAR, the FAR provision was published requiring it, I got an email from somebody asking if I would come in to do training for this group of them so that they could check the box and say they were certified in having a compliance program. And I had to explain to them the difference between a compliance program and training session. Although training is an important part, a piece of a compliance program. We did receive a question a bit earlier, the panelists did, about whether debarment has been a successful tool in basically promoting compliance. And I think there's a great anecdote, particularly from the person who asked this question, of I will not mention their name, but everyone can probably guess who it is. In 2000, about a decade ago, a very, very large British defense contractor had a very high profile corruption scandal and was actually allegedly not cooperating with the UK, decided not to prosecute, and allegedly the United States was trying to prosecute and ultimately did prosecute the company. And the company wasn't cooperating. And it wasn't until one of their biggest customers, a section of the Department of Defense, went to this company and said, hey, let's chat. You do realize debarment's a risk. And it wasn't until that moment that this large defense contractor began cooperating not only with this US agency, but also with the Department of Justice inquiry. And as part of that discussion led to a significant overhaul of the company's ethics and compliance program. So I am of the belief that not only has compliance globally been driven by things like the OECD Anti-Bribery Convention. I won't really say it's UNCAC, but it's a lot of the countries passing FCPA-like laws, with the MDBs also having compliance expectations, but really this global compliance standard that's very much emerged and expected now of companies. But that has definitely been a huge impetus, but we cannot forget that the ultimate threat is not for companies fines and penalties, it's exclusion. Because exclusion knocks out government revenue streams for many companies. It makes them ineligible for commercial loans. It makes them ineligible for licenses. It has potential cross-debarment repercussions. So to me, yes, the fines and penalties have been a huge driver of corporate compliance and change, but that ultimate threat is always a threat to take away a government revenue stream.
Thank you all. I want to go back to something that Mirella mentioned initially. She said that there seems to be a convergence of systems, yet at the same time, if we look more detailed in the systems, we see all these differences. And I wanted to ask the panelists what they think about cross-debarment, meaning recognition of debarment and exclusion decisions of one jurisdiction by another jurisdiction. Do they see, does everybody see a trend towards that direction? Are there any pitfalls, any advantages and disadvantages? And I would like to start with Mirella, since she brought the convergence up earlier.
Okay. Well, I think this issue must be related to the purpose of the exclusion system in general, because when you address the reliability of the bidder, then you may not simply ignore that the bidder was considered unreliable in other jurisdictions. So then you will have to consider how to check the reliability on the basis of your domestic law if this reliability was questioned under different jurisdiction. Again, my perspective is the European perspective, and it means that we have several domestic legal systems, but we come as in terms of the exclusion system in one EU law. The single market operates in a way that different jurisdictions open their markets, and with the guarantee of the equal treatment of each bidder, no matter from which member state it comes, which means we have to recognize the requirements. We need to evaluate the bidders in an equal way, so we may not ignore again whether or not there were exclusion grounds in different jurisdictions. And actually, Poland is quite an interesting example, because we had a change of the law last year, and before that, our law, domestic law, literally referred only to the, for instance, conviction under the Polish criminal code or other Polish acts. But nevertheless, the practice was that every bidder from other member state or also from other countries, even the countries outside GPA, which I mean, for instance, Chinese, were obliged to provide criminal records, were obliged to provide other document certificates to prove there are no exclusion grounds in their respective jurisdiction. So apart from, I mean, no matter, or despite there was the regulation that allowed only rely on the local convictions, the practice was we were checking whether or not such entity, such bidder is reliable under its respective jurisdiction. So that was the system, and I strongly confirm and accept this, because as part of the EU and a single market, we simply cannot avoid evaluating each bidder through the same requirements.
In Nikolaus, that's a very complex topic, right? We do not have it here in Brazil, but in Latin America, Argentina issued a decree a few years ago, sets forth as disqualifying circumstances if a company was convicted for a bribery case under the OECD convention, right, in another country. And I think the directory shows a wide spectrum of possibilities for debarment. It's hard to make cross debarment at a country level, to be fair. I think it is too complex exercise and might not be worth, because there are so many nuances. I believe Collin described earlier the possibilities to response, when, and that might open the room for endless legal discussions at the countries. But it's interesting because in the in situations in which there is no legislation allowing cross-debarment, some entities are finding ways to circumvent this. They sent questionnaires to the participants on the bid and ask, have you, your parent company or any affiliated company be debarred anywhere? So, and then they do not consider those companies for participate in that specific procurement. I think the consequence of these is that companies, I believe, they try to pay more attention to cases in countries which they typically do not do business and otherwise wouldn't bother to being debarred. Because when this, there is this cross debarred or these questions, then they have to address this issue in a country that otherwise they wouldn't mind, because they just did a one-off deal there, so forth and so on. But I think at the Multilateral Development Bank, I think it's easier. You have a sophisticated team. It's a smaller group of bodies. You can come to an agreement. But when we look at the directory, we see all sorts of possibilities, which I think at the country level makes virtually impossible to come up with such a thing.
Nikolaus, I'm sorry.
I just want to add, because the directory provides information that many countries has an exclusion list, and sometimes it is the basis for the decision of the cross debarment. Actually, that would be problematic, for instance, under the EU law, because such a list actually introduces the mechanism of automatic exclusion, which is not allowed. Like, every decision must be made on the facts. So this cross debarment would be problematic in this case.
I was going to say that Nicolaus, probably the name of the paper you can write is From Exequatur to Cross Debarment, which is probably the deep legal question. How do you move from, how do you apply extraterritorial the law to, other countries? Carlos mentioned that we have been able to do it at the multilateral development banks level, have this cross-department agreement. And if they ask me, I would say that that's probably one of the biggest tools that we have in order to have compliance in our systems and to make them work and try to further our idea of ensuring that all the money is being used for the purpose it was intended. But at the same time, I have to admit that there's other multilateral development banks, not just the ones that I mentioned, that would probably want to be part of this cross-department agreement, and haven't joined for many other reasons. But it's also a challenge at our level. How can we get other entities to come into the system, and whether or not is it advisable to have a larger system? So that the question is still up there. Mirela, I think that you made an excellent point that there's in the European Union, you actually have to have a process to be debarred, and bringing the cross debarment from another place directly into your system without having a process to defend yourself, it creates a problem. So I don't know what this is. Again, like I was saying, 5 years ago we didn't have compliance like we have it now. I don't know how this is going to look 5 years from now.
I won't
go
mince
ahead.
words. I think. Oh, sorry, Colin.
No, go ahead.
I was gonna say, I won't mince words. I'll be less polite than my fellow panelists. I think it's a terrible idea. The systems are too disparate. It's not even just that the rules themselves are disparate, but their application. Many of these regimes have rules in place and systems in place and barely use them. And then you have to worry about how it's been implemented, whether it's been done fairly, whether a system's been used for political purposes. There's so many complications. So I think the idea of either a automatic or somehow inflexible or rigid cross-debarment system is just fundamentally awful. I do think that considering debarment in a different jurisdiction should be a very important factor in that a suspension and debarment official should weigh when making an exclusion decision. So I think it should be taken into account, and it's a red flag and certainly should be evaluated further, but it shouldn't be some sort of automatic or rigid requirement for an exclusionary authority.
Well, all very, very, very good points. And I think, Juan's discussion and Carlos's discussion of the cross debarment agreement at the MDBs, I mean, this is me speaking personally, that's probably one of the only ways to do a cross debarment system properly, because that is a mutual agreement amongst the different MDBs that have signed on to that agreement, and that was entered into after an attempt and an effort to harmonize those systems as much as possible. And so there was sort of an underlying recognition that we are recognizing each other's debarments because of the similarities of our systems. What we often see in a lot of countries, in a lot of these jurisdictions, is they will recognize voluntarily, unilaterally. They will say, you were debarred in the United States, or you were debarred by the World Bank, therefore you're debarred here. And what is lacking in that type of system is that mutual recognition, but also sort of mutual evaluation of the systems and the differences and the reasons and the purposes, everything that we've just talked about. Jessica just mentioned, though, that talking about automatic cross debarment and the difficulties there. Nevertheless, there is benefit in having transparency of debarment decisions across borders and across jurisdictions. So in the next 5 minutes before we do some concluding thoughts, I just want to bring up that transparency question. There is a benefit, it seems, to having a public list and public information about debarments, but at the same time, that can lead to this risk that we just talked about with automatic cross debarments, other systems simply relying on a list because it's public and not engaging in that second level of investigation that we think is necessary. So I was wondering if any of you want to speak to that. I can call on one of you, but Jessica.
I think that gets to the point of why I think greater transparency is necessary. You know, the idea that you post a company or an individual's name, and even there's jurisdictions, as you can see in your study, that don't even provide almost anything. So so that's even more, to me, problematic, that information is not provided. But while I do appreciate the concern about weaponizing a name, I think the idea of having greater transparency would actually be helpful to companies. I'm sure they don't love to get their dirty laundry out there. I know they don't, in fact. But it is helpful from a perspective where you can see, because in some countries, a basis for exclusion in one may not be one in another. So having that additional detail might help tell the picture. But at its core, we and I say we as the kind of global we of civil society and people that are interested in these issues, we cannot actively assess the effectiveness of a system unless we have greater transparency into why companies are being excluded, their bases for being excluded. And that is one of my biggest complaints with the United States system, is that yes, we have a list, but it's so, opaque. And yes, the Interagency Suspension and Debarment Committee provides these kind of opaque, high-level statistics, but they don't really tell us anything about what's going on underneath the surface. So it's hard for us to really appreciate whether or not a system's effective. So when I see, some of the lists, I was looking up some of the lists, like in South Africa, where there's literally a line that says, the basis for debarment, and it can be fraud, and sometimes it's not more than that. But then at least give the contractor an opportunity to explain, okay, we now know why, you were excluded. Maybe you can give us some more information. That would be helpful. But I think greater transparency actually benefits everyone in the end of the day. And that's why that is my call and my plea. And any student that wants to write about it, I will happily assist with it, on greater transparency in all debarment regimes kind of across the board.
So I want the other panelists to weigh in as well. But before we do, I want to bring in a question that came up that I think is very good. Is what's the tension between improving transparency? So Jessica is very, very pro transparency, but there are regimes out there, data privacy regimes, that are directed to protecting particularly personal information of individuals. And so, do you see any tension there, and how can that be overcome?
I would just step back on the previous comment on the transparency, and I would add, as a general proposition, I think transparency is a good thing, right? And for many companies, exclusion, is not a concern. They don't sell to the government. They don't receive public incentives. They just don't care of being sanctioned. For those companies, however, oftentimes publicity is a concern, and their names will appear on background checks, right? So, for example, in Brazil, the CGU, the Office of the Attorney General, who is responsible for enforcing the anti-bribery law, they keep at the federal level a list of sanctioned companies. And when you look at the guidance of CGU, they say, did you look at these lists on your background check? So this is something that the companies are afraid of. To your last question, Collin, I think that is a challenge, right? But we need to be careful with respect to the companies. There is not much protection, right? But with respect to the individuals, to the extent that somebody was sanctioned in a final decision, I think it's fair to have that name included on the list. I think the challenge is that we have, I think, in many ways, two main models, right? We have some countries with highly centralized authorities or very qualified or specialized, in which the sanctions are applied in a correct due process, in a fair process. On the other hand, we might face authorities that have never brought an enforcement action. I was dealing with authority the other day who told me, and we never had a case like this. Some of them did not have the legal education. So that's a challenge when you are sanctioned under this circumstance and your name goes on the list, because you might, take the case to the judiciary. In many instances, the judiciary will not go through the merits of the case. We'll just check if there was any, procedural mistake, and then the damage is done, right? So I think that's a challenge.
So we are one minute over, but if there is anything that Juan and Mirella would like to conclude with, like just 30 seconds before we go.
I just, go, Mirella.
I just wanted to add that making the verdict, the conviction publicly available is a punishment under our Polish criminal law itself. So it is decided by the court. So that's the conflict probably with the transparency issue. We also in Poland had this experience with the exclusion list. And our example shows that this is very important, that bidders have effective remedies in order they can defend listing, and also they can have effective tool to be unlisted when the situation changes. It was not well done in Poland, and still we have some court cases for the damages from the bidders to the state treasury because of that list. So this is very important issue to secure interest of both sides. The transparency is one objective, but then the interest of the bidder is the other one.
Yeah, I just wanted to say that transparency goes hand in hand with due process, and it's key. Due process, especially in administrative procedures. Criminal proceedings, usually by and large in most countries, are afforded. The due process is afforded within those criminal proceedings. Some administrative proceedings in certain countries, they don't have a strong due process. So I just want to leave it at that.
And
Thank you all. Go ahead.
And I just wanted to congratulate the World Bank on this tremendous report and resource that you've basically given to all of us globally. I can only imagine the time and effort that went into this. So from all of us that study this area of the law, a thank you.
Well, thank you to everybody, and thank you to the contributors. Not only Carlos and Mirella, but I was looking through the attendee list and I saw a number of names that were integral in the directory as well. So thank you to everybody that made this possible. Apologies for going 3 minutes over, but this was a fascinating discussion. Thank you to everybody for attending. Thank you to the panelists for your insights, and thank you to GW and the ABA for co-hosting. Thank you all. Oh, and last point, this has been recorded and it will be up on YouTube, the GW Law's Government Procurement Law website this afternoon.